Well, thanks for watching Morning Live. Now, there's been a growing trend of citizens deciding to take control of municipal functions, some with, in certain instances, the approval of the courts. However, the recent case of a court interdict obtained by the Koingnaas municipality in the Northern Cape to prevent residents from fixing potholes and sewage leaks came as a surprise to some, considering that some courts have had different outcomes on similar cases. For example, the Magistrates Court in the district of Kgetleng Rivier in the Northwest Province granted an interdict forcing the municipality to relinquish power over to the Ratepayers Association to take full control of their water supply. In another judgment in the Eastern Cape, the High Court in 2017 granted permission to farmers to carry out road maintenance and charged the provincial roads department for the repairs. Now we're joined by Andreas Peens from Andreas Peens Attorneys for some discussion and perhaps a bit clarity on some of these issues. Mr. Peens, thanks so much for your time. Welcome to Morning Live.
Thank you. Good morning, and thank you for having me.
So perhaps just as a starting point, is it against the law for citizens or for particular groupings of residents, such as a ratepayers association, to conduct maintenance in their municipalities? And do local government authorities have powers to interdict citizens from stepping in and rolling up their sleeves, as it were, if they see that there is a collapse of service delivery around them?
Firstly, a shocking court order interdicting residents from conducting maintenance or repairs. My theory is that the residents took the law in their own hands by not following proper procedure, obtaining a court interdict or order covering them, and to allow them to fix or maintain government infrastructure. It is illegal to, out of own or let's say, take the law into your own hands. But if you follow the correct procedure, compelling the municipality to fix, and therefore, if not, then you as residents obtain an order to fix against payment. That is certainly the procedure to follow, as we saw in the Eastern Cape matter.
So you say fix against payment, Mr. Peens. What if the residents have this huge gaping pothole in a very busy road in town and they just decide they've had enough, they get some tar, they fill it, they fix it, end of story. Is that a problem?
Again, it's taking a matter into your own hands. Any procedure by taking law into your own hands is unfortunately illegal. You should compel the municipality to fix that pothole and obtain an urgent interdict to fix the pothole yourself. That is the procedure you need to follow.
So perhaps it brings us to the Northern Cape, the Koingnaas municipality. And as you said, rather surprising outcome. But you also point out that they did not follow proper procedure. But considering the other outcomes in similar sort of cases, where did they go wrong specifically?
I said my theory. I don't know for sure. What procedure did the residents follow in Koingnaas municipality? However, the correct procedure to follow is to firstly send a letter or two to the municipality indicating the problem, identifying the problem, and giving them time to respond. If they do not respond, then unfortunately you have to approach court to obtain the necessary interdict or a mandamus to compel the municipality for service delivery, and if not, then get an order. It says to get an order to fix the road in yourself, and I always say against payment, because obviously ordinary residents can't be out of pocket for a municipality failing to deliver services.
And of course, this is by and large, we're talking about instances where residents or residents associations have had the wherewithal, the financial muscle, etc., to actually bring the municipality to do what it's supposed to do. But what happens in instances where people are perhaps out in a far-flung rural area and roads perhaps are not up to scratch, or whatever other services are not being delivered? What sort of recourse do citizens then have in that regard, Mr. Peens? How do they make sure that the municipality actually does deliver?
Yeah, it's unfortunate that rural areas are struck hard by non-service delivery by local government. In an instance where there isn't enough people or there is not capital, then they should join a action group to assist them with such litigation against local authority, or at least extend a hand or invite them to assist ordinary citizens with legal action. And there's a couple of groups that will most likely say, yes, we will help. Yes. So that is what the residents must do. They must just seek legal advice. They will get it.
And in terms of seeking legal advice, what we have seen in some of these instances is that an aspect where the citizens choose to withhold rates and taxes if they feel that they are being failed by their municipalities at the local government level, as was the case at Koster in the Northwest Province. Speak to us, please, Mr. Peens, about the legalities of that. And again, what are the procedures to be followed?
Firstly, you have to declare your dispute with the municipality in terms of the Municipal Systems Act. By declaring this dispute, then you can withhold rates and taxes. In our instance in Koster, we obtained a court order that declared the valuation roll unlawful, and therefore the municipality have unlawfully charged or levied rates and taxes, and that is why the residents of Kgetleng Rivier, or some residents, are withholding their rates and taxes.
So if we go back to that example of what happened in Kgetleng Rivier, and we found there that the municipal manager, I think, was suspended as per the judgment for 90 days. Are you able to give us an update on what happened in that situation?
So the formal police charges or criminal charges was laid for contempt of court. The matter is currently pending, and the argument will be before the High Court in Mahikeng on 19 January for argument. And then should we get leave to appeal, the Bloemfontein Court, the Supreme Court in Bloemfontein, will have a final ruling. And if the residents are successful, the municipality will be imprisoned for 90 days.
So, with regard to that matter, there was also a question of sewer spillage, and has that been cleaned up as yet?
No, certain parts have been cleaned up, but I will say 75% have not been cleaned up yet. So it's still a problem, but we're working on it. At least the residents are cooperating and trying to, and let's say the residents, my apologies, the residents are being tasked or trying to resolve the sewage spill.
So at this point, in that particular municipality, where are things at? The Ratepayers Association, are they still basically in charge of things? What is the relationship with the municipality at the moment?
In May, the citizens gave back the municipal assets against payment because the court case didn't allow for a full takeover, if you want to call it like that. It was more like a curatorship at that point in time. So the municipality is currently in charge of service delivery, And it was just a couple of days, I want to say 2 or 3 weeks, then service delivery collapsed once more. The residents were again without water. But this evidence have been or will be placed before court once again. And then again, it's just a simple matter of following procedure to have the municipality held accountable for non-service delivery.
So it always seems like a dance that's happening there in Kgetleng Rivier. So where to from here? Because you said once the reins were handed back to the municipality, it was only a matter of days before service delivery collapsed again. So what are the citizens thinking at this stage? And also, just as a legal expert, can concerned citizens actually successfully call for a municipality to be dissolved before the end of term?
Calling for a municipality to be dissolved is a tall order. It can in fact happen. We saw that in the Makanya matter in, I think it was end of 2020 or beginning of 2020. However, it's my opinion that you should compel them and hold the management accountable in terms of the court order. Should they fail, then you should approach the court for a contempt of court application, holding them in contempt, where they will be imposed a fine or imprisonment, as the case in Kgetleng Rivier. And then the second step, my apologies, the second step for the residents is now to approach provincial government and national government, stepping beyond local government to see if they can get into some kind of working relationship in terms of a MOU, it's a memorandum of understanding, or alternatively, section, I think it's 97 of the Municipal Systems Act make provision for private citizens to do service delivery against payment.
Mr. Peens, we've just come from local government elections that were held on the 1st of November. Still no improvement?
No, in terms of councillors, there was an improvement, I think, personally. However, the municipal council hands is also tied in certain aspects. You can approach and you can lay or complain with a councillor, and it can it's a process. It will only escalate and escalate, but the right route would be to approach the court. It would be much faster, as in some instances the councillors simply do not care about service delivery.
Well, we'll leave it there for the time being. And of course, once the court decision is made, we certainly will pick up on it again. But thank you so much, Andreas Peens from Andreas Peens Attorneys, talking to us about the rights of residents in matters of service delivery. This following a court interdict that was obtained by a municipality in the Northern Cape, preventing residents from carrying out their own municipal maintenance. And love to hear your views on that at Morning Live SABC, as where you can send your tweet to.